Hello, I'm Dawn Eden Goldstein. I'm a canon lawyer on a diocesan tribunal, and you're watching episode 3 of my series, Lifting the Veil on Annulments. This series is my attempt to undo the opacity that surrounds canon law for people who are seeking to have a marriage that has broken down, declared null. I hope through this series to help you who are seeking an annulment to understand the process so that by presenting the truth, the facts about your putative marriage before a tribunal, you may obtain the declaration of nullity that you desire, provided that your union was, in fact, invalid. So, in the previous episode, we were using the grounds for nullity lists of the Diocese of Madison and the Diocese of Cleveland to better understand the universal law of the Church regarding on what grounds a tribunal may find that a marriage was invalid according to the law of the Church. The most recent ground that we were most recently considering was Canon 1095, number 2, which concerns a grave defect of discretion of judgment regarding the essential rights and duties of marriage. This ground is also called LDD, lack of due discretion. And what we began to discuss at the end of the previous episode was that many people think that they can have their marriage that has broken down declared null just because they and or their partner were immature. And this ground of Canon 1095, number 2, is the ground on which people will accuse their marriage of, or accuse themselves with regard to the entering into their marriage, that they or their partner were immature. But as I said in the previous episode, people can understand the essential rights and duties of marriage even if they're immature. People can choose marriage with a particular person and have it really be valid even if they're immature. And I gave the example of an aunt and uncle of mine who were quite young when they married, and they married validly. And they're, thanks be to God, still married today. So that's the bad news. The bad news is just because you and or your partner were immature doesn't mean that your marriage that is now broken down was invalid. For the rest of this episode, I'm going to be sharing with you the good news, which is that there is a far greater chance that your marriage might have been invalid due to Canon 1095-2 than you may think. And there's actually a far greater chance of it than the Diocese of Madison, which created the grounds list that I'm using for most of this series. There's a far greater chance that your marriage may be invalid than the Diocese of Madison thinks, according to their list, which is why I'm also using the Diocese of Cleveland's list. So first, let's go on the Diocese of Cleveland's list. I think they have some very helpful questions to ask yourself with regard to whether the ground of Canon 1095, number 2, might apply to your broken down marriage. The questions they ask, and this is on page 14 of the Diocese of Cleveland Understanding Your Marriage booklet that I've linked to in the comments of this YouTube, not the comments, in the description of this YouTube video. The Diocese of Cleveland writes, "To marry, a person must not be affected by psychological or emotional problems which prevent him or her from understanding the marriage he or she is about to enter." And then they ask, did either of you suffer from emotional or psychological problems which affected your decision to marry? Have you had lifelong mental health problems? Was the decision to marry impulsive? Was either of you gravely immature? Was your decision to marry caused by some pressing issue, e.g., a premarital pregnancy, desire to escape your home life, etc., which prevented you from making a free decision regarding marriage? Did others express concerns about your decision to marry? Did you see evidence before the wedding which should have told you not to marry, but you ignored it? Did you marry for the wrong reasons? So those are all things to consider if you're going to argue Canon 1095-2, either on yourself or on the respondent, which is your former spouse. Now, let's go back to the grounds for nullity list of the Diocese of Madison, and I'm going to tell you why I think that the Diocese of Cleveland's questions are more helpful than the examples provided by the Diocese of Madison. So the Diocese of Madison provides a couple of examples of when 1095-2 grave defect of discretion might be applicable. And these examples that they apply, this is on pages 1 and 2 of the Diocese of Madison's grounds list, linked in the description of this video on YouTube. They provide a couple of examples, which I'm not going to read. You can read them yourself of where this might be applicable. And as I say, I think the examples they offer are fairly extreme. And then they offer a number of examples of when this ground is not applicable. Now, I'll tell you in a nutshell why I think the Diocese of Madison's examples of why this ground may not be applicable, why I think they're not looking at the whole picture here, let's say. I think that the Diocese of Madison is not adequately accounting for the great prevalence of childhood trauma and particularly abuse, be it physical abuse, verbal abuse, sexual abuse, that people experience in childhood. They're not accounting for how that may affect people in their decision to marry. I have written books on healing from abuse. One of them is my piece, I Give You Healing Sexual Wounds with the Help of the Saints. Another of my books is called Remembering God's Mercy. Those are both under the pen name Dawn Eden. And in researching these books and in giving talks to Catholics after writing these books, I've discovered that the incidence of childhood abuse, be it physical, verbal, or sexual, is far greater than is reported. And at the tribunal, in looking at people's descriptions of their home life and of witness descriptions of their home life during their childhood, I see that there's a lot of behavior that people experience in childhood that they may not personally write as abuse mentally, but that is abuse. And a psychologist will tell you that these types of abuse, these types of trauma, can really affect a person's freedom to make a decision with regard to whom to marry. And the Diocese of Madison, in their own grounds list, isn't really stating what the Church believes is relevant with regard to Canon 1095. What the Church believes is relevant is in the document Dignitas Connubii, which I'll also link to in the YouTube description. In Dignitas Connubii, Article 209, it speaks about how in cases of grave defect of discretion, due discretion, the judge is to seek an evaluation from a psychologist of this person, and the psychologist is to report on what was the effect of this psychological anomaly that a person had, what was the effect of it on the critical and elective faculty for making serious decisions, particularly in freely choosing a state in life. What that means is that if a person is arguing that they or their spouse was suffering from a grave lack of due discretion at the time of the vows, a psychologist evaluating this person or their spouse, the respondent, is to evaluate whether this person, you or your spouse, whoever's being evaluated, a psychologist is supposed to ask you questions to determine whether you had interior freedom. So what can impede interior freedom? What can impede interior freedom are psychological anomalies, conditions, disorders caused perhaps, there are a number of things that it can be caused by, but one of those is caused by in colloquial terms, hang-ups, because of having a wrong idea of oneself or how one relates to others. That can be caused in part, not necessarily, but in part by trauma. So I think this is important enough that this should stretch into another episode. But I'm going to close out this episode by going through the Diocese of Madison's examples of what is not lack of due discretion to say why I think these examples could concern lack of due discretion. So I'm looking at the Diocese of Madison's page 2, example A. I'm going to read this very quickly. The bride suffers from moderate depression and anxiety brought on by the stress of nursing school, and she is receiving professional treatment. So it goes on, and they're saying that this is not a case of lack of due discretion. So I would rewind and say, wait a minute. If the bride is receiving professional treatment for moderate depression and anxiety brought on by the stress of nursing school, how do we know that this stress and anxiety that has come on with nursing school was not latent due to certain vulnerabilities that the bride had growing up? This is a thing with trauma. People who suffer trauma in childhood can try to bury that trauma and try to become, people pleasers, or try to develop certain coping behaviors that can then no longer work once they're under new levels of stress, such as being in school, or being in a difficult relationship. So that's why I think example A of the Diocese of Madison may not be as foolproof as they think it is with regard to an example of what is not 1095-2. Example B that the Diocese of Madison uses is the groom has never been ambitious or good at school. In college, he mostly parties and plays video games with friends, occasionally making recreational use of marijuana. And it goes on, and it says, this is not an example of grave lack of due discretion. Well, again, what was going on with the groom that he was interested in partying and video games and marijuana while in college? Could there have been something in his childhood that led him to not take school seriously. That's something that a psychologist could find out. Then it says, neither the bride, this is example C of the Diocese of Madison's list of things that are not Canon 1095. Neither the bride nor the groom has ever suffered from any serious psychological problem. They decide to marry at age 20 when the bride becomes pregnant because they feel it is the right thing to do. Again, why were the bride and the groom fooling around at age 20? Why did they feel that they had to go all the way and not having the not thinking about that sex makes babies at 20? So could there have been some sort of insecurity in their past that would have led them to seek love through sex and be very risky and audacious in an unhealthy way about this? Example D of the Diocese of Madison on what is not 1095-2, I actually think is a pretty good example. So let's continue this in the next episode, and I'm going to talk about what you can expect to be questioned about by a psychologist or by a judge if you are arguing that your marriage was null on the grounds of Canon 1095-2, lack of due discretion. Thank you for your comments, which I really appreciate. Thank you to those of you who've encouraged me to continue this series. It's because of your encouragement that I'm continuing it. I'll try to answer the comments that I can. Please know that the comments are public, so don't ask any question in the comments that you wouldn't want others to see. I'll try to answer your questions if I have the time and if I think that answering them would help others. Thank you. Hope to see you next episode. God bless you.